Good morning, ladies and gentlemen. We have the privilege of living in a free and democratic society. And the continued existence of that free and democratic society depends on the law. Lawyers, as guardians of the law, play a vital role in the preservation of that society. And the fulfillment of the role as a lawyer requires unwavering commitment to the core values of the legal profession. And a consequent obligation is that lawyers must maintain the highest standards of ethical conduct. And that's what this case is about. It's about lawyers and ethics. The scales of justice sit firmly on the book of ethics, and justice cannot exist without ethics. Ethics are at the very heart of the legal profession. The legal profession would not exist without ethical standards. Without ethics, the legal profession cannot survive. Without the legal profession, law cannot exist. And without law, our society as we know it would disintegrate. This case may be about one lawyer and one law firm, but it's about more than that. It's about the future. What if all law firms decide that client interests and money is more important than maintaining the ethical standards demanded by our profession? That's why you, ladies and gentlemen, have an important job today. In fact, it might be the most important job you do in your lifetime. You have all the power. And I ask you to use that power to protect the future of the legal profession and the future of our free and democratic society as we know it. If law firms are allowed to treat their lawyers the way Morgan and Sterling treated Harvey, well, then that threatens the world as we know it. So thank you. Thank you for agreeing to do this job. Thank you for your commitment to your job as jurors. Thank you for your patience and your attention. Harvey admits he made some mistakes. But what's clear from the evidence is that there are 4 truths that resolve this case. Harvey was right. You saw that Mr. Sterling ended up filing the responses as Harvey had recommended. Schneider was not prejudiced at all. The deposition was taken on time, and it was only 2 weeks over Christmas and New Year's, when not much work is done anyways. Firing was a harsh and unwarranted punishment for Harvey's actions in light of his prior performance. And finally, no lawyer should be made to set his ethics aside in the interest of an unreasonable client mandate. So what are we asking of you? You heard Mr. Monet come and tell you the economic loss that Harvey has suffered. And that's all we're asking for, the economic loss. We're not asking for any mental pain and suffering that Harvey's suffered from Sterling and Morgan's actions. So as you go through the verdict form, I ask that for question 1, you check yes, that he did have a contract. For question 2, if you get there, I ask that you answer yes. Was his discharge a violation of public policy? For question 3, was he discharged for just cause? I ask that you answer no. And the final amount of damages, you heard Mr. Monet tell you that it's about $8.3 million that will fully compensate him for his economic loss. And this is just a fraction of what Sterling and Morgan will make over their lifetime. Help make Harvey whole. Thank you. Good afternoon, ladies and gentlemen. Again, my name is Bethany Schneider, and I had the pleasure of speaking with each of you during voir dire. Again, it's my distinct privilege to represent the defendant in this case, Philip A. Cup. Now, as I was listening to Miss Logan's opening, I was reminded of a radio program that ran from World War II to actually 2009 with a host named Paul Harvey. that's called The Rest of the Story. Part of that radio program was to tell stories that had forgotten facts or little-known facts that at the end of the program, he would reveal the key fact. And when he did, he would use the tagline, "And now you know the rest of the story." Ladies and gentlemen, that's my job here today as defense counsel. It's to bring you the rest of the story. It's to bring you, as judges of the facts, the rest of the story that you need to know to make a determination in this case. That's what you are. You are the judges of the facts. The court will give you the law, but you're going to take all of the evidence in this case and decide how to apply those facts to the law. The good news for you is that when you get to the end of the case and you've sat through all of the evidence, you'll find out that this is actually a pretty simple case. This is a case that boils down to carelessness and distraction and taking personal responsibility for that carelessness and distraction. So I want to spend some time going through those claims with you and showing how the evidence that you'll hear in this case goes with each of those claims. So the issues you're here to decide. First, who was at fault for the accident? Now you heard the plaintiff's side of the story. So the rest of the story is that you'll hear Mr. Acup tell you that he took all of the necessary and appropriate safety precautions that day on November 18th. But what you'll also hear is when the plaintiff, Ms. Hertz, gets up to testify, she'll have to admit that she was preoccupied that day with an important presentation that she was going to give, that she was in a hurry because she had overslept. Now, plaintiff's counsel told you that she had time to stop for coffee and a newspaper, as was her routine. But what you'll hear is that no one reported any coffee or newspaper at the scene of the accident. You'll also hear that just minutes before her presentation was set to begin, the meeting was set to begin at 8:45, she steps off the island in the middle of the street, not even looking for the walk sign, and outside of the crosswalk. Now the second issue for you to decide is what injuries, if any, were sustained as a result of this accident. So what you'll have to decide is the emotional and psychological problems that Ms. Hertz will explain to you, were those a cause of this accident or something else? And what you'll hear is that Ms. Hertz, unfortunately, had her mother pass away just a week after the accident. The final question for you will be, how much should Ms. Hertz be compensated for her injuries? So for that question, you'll have to take into account, was she really up for promotion? How long had she been suffering the injuries that she claims? And is she still suffering those today? And has she tried to get another job to mitigate her damages? Another less stressful, challenging job that maybe could help her financially. So I'm about to sit down, ladies and gentlemen, but I want to ask you just to do one thing. As you promised to do in jury selection, because the plaintiff gets to go first, I just ask you to keep an open mind and reserve judgment until you hear the defense side of the case and the rest of the story. Thank you. So Mr. Acup, I want to start out by asking you some basic questions about safety rules of the road, okay?
Okay.
Now, as you told this jury, you've been a bus driver for 9 years. Is that correct?
That's correct.
All right. And so, of course, you know that one rule every driver learns is that in driving school is to watch out for and yield to pedestrians, correct?
Absolutely.
All right. And that's one of the basic elementary rules of driving on the road, correct?
Correct.
Pedestrians always have the right of way. Isn't that true?
That is correct.
Actually, as you're driving around, signs are everywhere. It's the law to stop for pedestrians in the crosswalk, correct?
Absolutely.
You agree that watching out for pedestrians is one of the most important aspects of your job, transporting men and women around busy intersections like the one at issue in this case, correct?
Yes, ma'am.
And along with the rule of watching out for pedestrians, when you're driving is being aware of whether a walk sign is illuminated, correct?
Correct.
And when those walk signs are illuminated, pedestrians have the right of way to cross the street, correct?
Correct.
And it's your duty as a driver to be aware of whether the walk sign's illuminated or not, correct?
That is correct.
Actually requires you to take additional safety courses, don't they?
That is correct.
And in fact, they require you to take these courses on a regular basis, correct?
That's correct.
To make sure you're aware of any new laws that come out that would affect your driving on the road, right?
Absolutely.
And in those safety classes, they teach you the traffic laws, correct?
Correct.
And it's very important as you're driving to be aware of all traffic laws, right?
That's correct.
And as a bus driver, you want to obey those traffic laws, don't you?
Of course.
You mentioned that you were in line for promotion at the time of the collision. The jury has heard some suggestion that you actually had an unfavorable evaluation and were not in line for promotion. Is that true?
I believe the last formal evaluation that was done by Ralph King, who was my supervisor at the time. He thought that I did an adequate job, at my position, but that he didn't see any motivation for promotion, movement on my part. But we had worked those things out, and he actually was instrumental in organizing the presentation, helping me to make the presentation to the board of directors. I had worked on a project that was going to save the company a good deal of money, and Ralph was very enthusiastic about this, and he was the one that suggested that a promotion possible presentation.
Okay, so it was Mr. King who actually put you up for the promotion in that presentation. Is that right?
Yes.
Is that what you're saying?
Yes.
Okay. What was the date of that evaluation?
That was it was quite a while before the accident. Maybe, again, my recollection is not great with dates and things. It might have been a year and a half before.
Okay,
something
well,
like that.
would you like to take a look at your evaluation?
Sure.
Maybe that would help you. Is this the evaluation that we've been discussing?
Yes, it is.
Do you see the date here? January
Yes,
15th, 2013?
Yes.
When was the accident?
So November of 2013.
So was
it
there some
about
time?
almost a year. Yeah.
Did you have to go to the hospital
Yes.
after you were hit?
Yes, I did.
Were you in any pain?
Oh, yes. I had a headache. Felt like my head was in a vice. My neck was stiff as if it had been whiplash. I felt really groggy, confused, and I'm also, it felt frightening to come to with a lot of people crowded around me asking questions.
Did you have to be strapped in as you're being transported to the hospital?
I did. The paramedics strapped me to a board and put a neck collar on me, and I'm a bit claustrophobic, so that was really sort of torturous. And I asked if they had to do that, and they said that was the normal protocol for any possible head, neck, or back injuries.
Now, the defense has suggested that all of the emotional and psychological injuries that you suffered are actually due to the fact that your mother passed away about a week after the accident. Can you please tell the jury how your mother's death affected you?
My mother and I had a bit of a distant relationship. I was really raised by my grandmother, who had passed away when I was in college. My mother had a drinking problem, and as a result, she had a long illness with cirrhosis. She was suffering a great deal. I didn't see her very much, but of course it was, I was so sorry about her condition, but at the same time a little relieved at her passing because she really was suffering so much and so much pain. She felt that it was time to go.
So do you think that the emotional and psychological injuries that you're suffering today are caused by your mother's death?
Not at all.
And in this case, you were asked to do an evaluation of economic loss for the plaintiff, Mr. Gordon, correct?
Yes.
On average, you do about 20 or 30 of those evaluations per year, right?
That seems about right.
And a majority of those evaluations are for plaintiffs as well, correct?
I'd say the majority, but not all, but yes.
But the majority are for plaintiffs, right?
Yes.
You charge $5,000 to complete these evaluations, isn't that right?
Yes.
And that's what you charge in this case.
Yes.
So I'm going to take this marker here, and I know I'm not the mathematician, but if you do 20 to 30 evaluations per year and charge $5,000 per evaluation, that is $100,000 to $150,000 a year just based on doing those evaluations, right?
Yes, that's right.
And that's not counting the salary that you get in your day job as an assistant professor. Isn't that right?
Yes, correct. That's a different salary. Yeah.
Over the course of your career then, since you said you've been doing this for 20 years, just to do these evaluations, you made $2 to $3 million, correct?
That seems about right. Yes.
And that's significantly more than what you've been paid as an assistant professor. Wouldn't you agree with that?
Yes, it is.
And these figures don't even include the hourly rate that you charge to actually testify in a deposition or at trial as an expert witness, right?
Yes, that's a separate charge, which is not very different than you'll find across the field.
Okay, but you do charge an hourly rate when you testify in a deposition or a trial, like you're here today, correct? And that's $450 an hour.
Yes, it is.
So in addition to that $2 to $3 million over the course of your career that you've made from the evaluations, you've also made whatever hourly rate, $450 an hour, for the 3 to 4 trials a year plus any depositions you've given. Isn't that right?
If it requires it, yes, that's it.
And just like we talked generally, your evaluations are based on facts and assumptions, correct? So I want to go through with you the facts and assumptions you based your opinion on in this case.
Okay.
Now the first fact that you based your opinion on is that Mr. Borman will retire at age 68. Is that right?
Yes, that's one of the assumptions made.
And to arrive at that figure, you looked at two things, correct?
Yes.
One was the statistics on retirement age that you got from the U.S. Department of Labor, right?
That was one of them.
And according to that government publication, Mr. Borman's statistical work life would be 64, correct?
Yes, we also relied on actual conversations with Mr. Bowman too.
And I'm getting to that, but just for this question, according to the statistics that you looked at, his retirement age would be 64, right?
Yes.
That's 4 years younger than the age you chose, correct?
Yes, that's right.
And the reason you chose a higher age was because you had a discussion with Mr. Gorman, correct?
It was that among other things, but yes.
All right, well, let's talk about the discussion you had with Mr. Gorman. When you talked with Mr. Gorman, he told you that he believed he would work until age 70 because he's in excellent health and has a desire to work in the legal field, correct?
Yes, that's right.
You'd agree with me, Mr. Monet, that people's health can change, right?
It can, yes.
And you'd agree, Mr. Monet, that a person's desire to do a job can change, correct?
Anything can change, yeah.
Right, anything can change. Isn't that right?
Mm-hmm.
Neither are absolutes, are they?
In this case, no.
But you took Mr. Gorman at his word, didn't you?
Yes, I did.
And you chose a figure that was different from the government statistics in considering your opinions.
And being fair with it, though, I also didn't choose only his number. I came to a number that was between the government statistic and what he provided to me, too.
But you'll admit that choosing the age 68 was a matter of judgment, wasn't it?
Mm-hmm. Yeah.
Isn't it true, Mr. Monet, that you made no attempt to determine what the average retirement age was at Sterling and Morgan
No, I did
or any other comparable firm, did you?
not. No.
So, let's be clear. This is an assumption, correct?
That is an assumption.
The next fact that you based your opinion on is that Mr. Gorman would become a partner at Sterling and Morgan, correct?
Yes.
And that's based solely on what you were told by Mr. Gorman and Mr. Gorman's lawyer, isn't it?
Yes, he said that through other conversations that he was looking to be a partner, and other members of the firm had told him the same way.
You didn't talk to those other members of the firm, did you?
I did not know.
As someone who does a substantial amount of litigation work, you're familiar with the firm Sterling and Morgan, right?
Fairly, but yeah.
You know it's a prestigious firm, correct? And you know that not every associate who works at a big prestigious firm makes partner, do they?
No, I wouldn't think that anyone would.
Most times it depends on the individual circumstances, correct?
Yes.
In fact, you're aware or not that 5 out of the 8 associates in Mr. Gorman's class did not make partner when they were up this past year.
Yes.
The same year that Mr. Gorman would have been up for partner, right?
No, actually, I'm not aware of that.
Okay, well, you'd agree that that would be important information to know in considering your opinions, correct?
If they were the ones that I was doing the report for, but it was for Mr. Gorman, who was not one of those. He did not have that opportunity to.
Right, but when considering in your opinions that he would become partner, wouldn't it be important to know if the firm's actually making people partner?
It would be, yes.
Isn't it true you did not undertake any investigation into the requirements for partnership at Sterling and Morgan?
No, I did not look into that.
You have no knowledge of partnership criteria at Sterling and Morgan, do you?
No.
And you don't have any knowledge whether Mr. Gorman actually met that criteria, do you?
Other than conversations I have with Mr. Gorman, no.
And you've not received any independent information other than from Mr. Gorman or Mr. Gorman's lawyer about his prospect for making partner, do you?
No.
So you'd agree then that this is also an assumption.
Yes.
That's correct.
And you understood that when you issued your report, you were supposed to provide all of your opinions in this case, correct?
Correct.
But you didn't mention anything about Ms. Hertz's mother in your report, did you?
That's correct.
In your report, you concluded that Ms. Hertz had major depressive episode, correct?
Correct.
Now, you told this jury that you're board eligible, right?
That's correct.
You're familiar with the American Board of Psychiatry and Neurology, correct?
I am.
That's the board certifying authority, right?
Correct.
In order to be board certified, you have to take an exam, correct?
Correct.
Isn't it true that board certification is a distinction for doctors who pass that exam?
It varies depending on who you talk to.
Well, isn't it true that when doctors call themselves board certified, that means they've passed an exam?
Correct.
You haven't passed that exam, have you?
I haven't taken the examination.
Okay, so you haven't taken or passed the examination, correct?
Correct.
So you're not board certified, are you, sir?
That's correct.
Now, isn't it true, Dr. Neuro, that the board actually discourages the use of the term board eligible because it's misleading?
That's correct.
And you're aware that, in fact, the board actually puts on their website that they don't recognize that term.
That's correct.
Let's take a look. Right on this website of the American Board of Psychiatry and Neurology, it says, the ABPN does not recognize or use the term board eligible and does not issue statements concerning board eligibility. You would agree, sir, that it's important for you as a physician and as an expert to understand a patient's complete medical history in order to assess the cause of symptoms, correct?
Yes, absolutely.
The first time you said that you ever treated Ms. Hertz was December 30th, 6 weeks after the accident, correct?
Correct.
You were not her primary doctor, were you?
No.
Dr. Bombay was her family doctor, correct?
That's correct.
And she saw Dr. Bombay before she came to see you, didn't she?
I believe so.
But she did not go to see him until 2 weeks after the accident, did she?
Correct.
And her only complaint at that point to her family doctor was that she was having trouble sleeping, wasn't it?
I believe so based on the notes. I don't actually recall what she reported to Dr. Bombay directly.
Well, if I represent to you that Ms. Hertz has testified that her only complaint to her doctor was sleeping problems, you'd have no basis to disagree with that, correct?
Correct.
Dr. Bombay prescribed her a sleeping pill at that visit, didn't she?
That's my understanding.
But Ms. Hertz stopped taking the sleeping pills a few days later, correct?
Correct.
You haven't seen Dr. Bombay's records, have you?
I don't. I have not.
And you never sought to obtain his records?
That's correct.
Or asked Ms. Hertz to obtain them and give them to you, right?
That's correct.
You've never had any contact with Dr. Bombay about Ms. Hertz or her past medical history, correct?
I'm sorry, can you repeat that?
Sure.
Yeah.
You've never had any contact with Dr. Bombay
correct.
about Ms. Hertz or her past medical history, have you?
That's correct.
So in looking at the differential diagnosis you did here, when Ms. Hertz first came to see you, she told you that she was in good health prior to November 18th, didn't she?
That's correct.
And you relied on that statement in forming your opinions in this case, right?
Correct.
You never took any steps to verify that information, did you?
Well, the history is in and of itself the verification of that to a degree.
The patient's own history,
That's correct.
but you never obtained or reviewed any medical records from prior to your treatment of her, right?
That's correct.
You never talked to any of her physicians who had treated her over the years, did you?
That's correct.
You never obtained her pharmacy records to see what medications she may have taken in the past.
Correct.
You never talked to her family and friends about any symptoms she had ever experienced in the past.
Well, actually, sorry, to correct that statement, regarding the medications, part of our initial interview is called a medication reconciliation. And so pharmacy records and these electronic medical records automatically populate with that information. We just tick off whether or not they're taking it. So that is actually part of our historical component.
You're saying that when you first saw Ms. Hertz, her medication just magically popped up on your screen?
It's not magical. Actually, it's part of this Obamacare initiative for one unified electronic medical record. And so, for example, any pharmacy prescribed medication or any health system that actually shares an electronic medical record automatically ports that into our system. And then we have to do, by law, what's called a medication reconciliation, meaning we have to go through those records and say, oh, you've been prescribed this, are you taking this, and why are you taking this? And that's the definition of medication reconciliation.
But that's not contained in any of your medical records, and you haven't produced anything about her past medications, have you?
Well, I mean, by doing medication reconciliation, if it's not an active medication, then it doesn't actively populate into the record. That's correct.
Okay, so now I get it. You wouldn't know any prior medications that she had taken in the past. You would just know any medication at the time, is that right?
Well, there are some medications that have been, for example, sent to a pharmacy. Patients don't necessarily fill those, so you might say, oh, are you taking this medication? No? Oh, okay, why not? And then that information, that discussion is not always documented extensively in the chart, but it will drop off of the chart if you say the patient's not taking it, because you've reconciled their active medication list, which is the only thing that's required to be documented, and the fact that you've done a medication reconciliation.
Bottom line, Dr. Neuro, no medications are mentioned in any of your records or in your report, correct?
Correct.
Now let me back up. If you did look at her prior medical records and saw that she had actually suffered some of the same issues in the past as she is now, that could impact your opinions in this case, correct?
Yes.
But you didn't do that, did you?
Can you restate that question?
You didn't look at her past medical records, right?
Correct. I didn't have the extensive past medical records of her entire past.
Isn't it true, Dr. Neuro, that this is not the first time that Ms. Hertz has had to seek mental health treatment?
From my understanding after the fact, that is correct.
So you're aware then, it sounds like, that Ms. Hertz actually had to see a psychiatrist when she was in college, correct?
Yes, that is my understanding.
And that would have been important for you to know as you were treating her, wouldn't have been?
It could have been an element that was important, that's correct.
Now on direct, you told this jury that you diagnosed someone with a brain injury